Well, hello and welcome to Newscenter. I'm Ashmit Kumar. Now, in a major relief to Congress leader Rahul Gandhi, the Sessions Court in Gujarat's Surat district has granted him bail in the 2019 defamation case and has set 13th of April as the next date for hearing. Now, in his first reaction after this relief, Rahul Gandhi said, and I quote, "In this fight, truth is my weapon and support." End of quote. Gandhi had filed an appeal against his conviction in the defamation case before the Surat court. He was accompanied by his sister Priyanka Gandhi Vadra and Chief Ministers Ashok Gehlot, Bhupesh Baghel and Sukhvinder Singh Sukhu. Along with them, party workers and leaders from across the state gathered in support for the former Congress president. The court had convicted Gandhi for his remarks on the Modi surname and sentenced him to 2 years imprisonment, leading to him being disqualified as a member of parliament. So what does the road ahead for Rahul Gandhi look like? Well, to take this discussion forward, I'm now joined by Mr. Sanjay Hegde as well as Mr. Vivek Sood, both senior Supreme Court advocates. Gentlemen, thank you so much for joining us. First question, as far as the takeaways from today's order are concerned, the bail has been granted, but there is no stay of conviction. What then does that mean for his disqualification? Does it continue to be in effect? Or is there a question mark now on it after the grant of bail? Mr. Hegde, to you first.
Well, stay of conviction has not yet been granted simply because the complainant needs to be heard. So notice has been issued to him, and that part of the order and the hearing will take place currently on the 13th of April. It doesn't mean that a stay of conviction has been ruled out, nor does it mean that it is an automatic given. So we shall have to see what happens on the 13th.
That's an interesting clarification. So no stay of conviction, importantly, and that essentially means that the disqualification proceedings continue to be in effect. There is no change in status quo as far as disqualification is concerned. Mr. Sood, let me come to you now, addressing the elephant in the room. We've seen the story play out since the morning when we woke up with the morning cup of tea. The story has been playing out, and it, of course, has been played on account of various Congress leaders, Congress workers descending upon that Sessions Court in Surat. The charge that is being leveled by the central government is that all of this show of support is designed to intimidate the Sessions Court judge. The opposition itself, Congress itself, is saying that, look, it's a legitimate show of protest, a sign of protest against this conviction. Your take on that?
You know, whenever these convictions happen, whenever these appeals are filed, it is very frequently seen that the family members and friends and others do congregate, you know, in support of the accused or the appellant or the convict. So, you know, I think it will be too far to say that it is designed to intimidate the court. But definitely it does, in my view, amount to playing to the gallery or something like that. But I would not say that, you know, this is unjustified or it has any intimidating effect on the legal process. The judges are independent. They have an independent view. The learned judge has applied the law and he has granted bail to Mr. Gandhi. So that's my take on what's playing out in the media.
Interesting. Mr. Hegde, same question to you. We're seeing the likes of Ashok Gehlot, Bhupesh Baghel, Sukhvinder Singh Sukhu. We've also seen Priyanka Gandhi Vadra descending on that Surat court. Your take on the visuals that we have been seeing since morning and the centre's charge that, look, they're trying to intimidate the judge here by the show of force.
Well, I don't think judges can be intimidated by whoever happens to come into court or outside court. That doesn't happen. The second part is that, you know, in my days when I used to file matters, there were clients who told us that you have to file this matter between such and such a time and my astrologer or my Babaji will accompany you and bless the papers. So there is not only a participation of the person filing the appeal, but the extended family and the neighbors and everybody likes a good tamasha and everybody likes to show solidarity. So I would not be reading too much into it. Of course, it makes for interesting visuals, and visuals is what drives politics. So, well, the BJP might have a complaint, but then it was a BJP member who filed the original complaint, wasn't it?
Sure. Well, so just another day on the political calendar. We'll take it as that. But Mr. Hegde, let me continue with this. The first point that you had raised is that there is no change in status quo as far as disqualification proceedings are concerned. Bearing that in mind, the strategy that Congress appears to be going for is that we want to address the issue at the very fulcrum, at the very heart of this, which is the conviction itself. They've not explicitly issued a legal challenge to the disqualification notice and the disqualification proceedings. What is your reading of this strategy by the Congress? Is it a smart strategy to not also challenge the disqualification proceedings themselves?
No. See, the disqualification has come into effect because of a Supreme Court judgment in Lily Thomas's case. To ask the Supreme Court to review Lily Thomas or to reread Lily Thomas, that's a long shot, and it will take its own sweet time. That is unlikely to provide immediate relief, where a simple matter of a stay of conviction pending the appeal. It could be granted by the district court. If it is not granted by the district court, that non-grant can be appealed all the way to the High Court and to the Supreme Court. I think that's better and safer strategy. Vivek is here. He will tell you that we lawyers tend to keep the issue as narrow focused as possible. Lawyers and judges answer and question only that which is strictly relevant. Don't go all over the countryside.
Sure. Mr. Sood, Mr. Hegde was alluding to your take on it. Let's get you in on the subject as well. As far as the challenge that was anticipated by the Congress, it was anticipated that one, they'll be challenging the conviction in the Sessions Court. And number two, it was expected, it hasn't happened yet, it was expected that the Congress and Rahul Gandhi in particular will also be challenging the disqualification notice. That has not happened. Your reading of this strategy by the Congress to go and only approach the Surat court?
I think time will tell as to what will be the strategy of Mr. Rahul Gandhi. But I agree with my good friend Sanjay that since the disqualification is a fallout or a consequence of the conviction, so it's best to attack the conviction and try and get a stay of the conviction. Because if you can get a stay of the conviction, then as a consequential relief in terms of Lok Prahari, judgment of the Supreme Court of 2018, the disqualification goes. Now, insofar as the challenge to disqualification itself is concerned, some PILs, etc., have already been filed in the Supreme Court that the bar should be lowered and Section 8, should be declared unconstitutional, etc. So the challenge has already come. Therefore, I think all these interesting legal issues will be gone into. But one can see the strategy with clarity that, first he has obtained bail. Now, bail was a routine. In such cases, bail is a routine. Bail and suspension of sentence is a routine in such matters. And now the stay of conviction, definitely it will be heard in the court. It will not be a routine matter. It won't come, so easily. It will depend upon so many factors, prima facie case, etc., etc. So let's see how this pans out in the Sessions Court on 13th of April.
Sure. Mr. Hegde, let me also, talking about the fallout of the disqualification proceedings, there is also this apprehension within the Congress that we could have the Election Commission ask for a by-elections in Wayanad now that Rahul Gandhi stands disqualified. Is that a legitimate fear? Would the Election Commission be acting within its powers if it were to go ahead and announce the by-election? It hasn't done yet. In fact, when the dates came out for Karnataka, it was anticipated that the by-election dates may be announced. It hasn't happened yet. But is that something that the EC would be within its powers? Is that a legitimate concern?
There is no bar on the EC currently from declaring the by-elections. And in fact, they did it in the Azam Khan case. So yes, if the Election Commission were also to rush into it, then possibly there would be fresh causes of action. But I do think that the Election Commission has decided to wait and watch, because there was a 30-day stay on the sentence itself earlier. Now there's a stay for a longer period. And in fact, even my reading of the Lily Thomas case, there is a point of law to be argued there. Because Lily Thomas says that no sooner that there is a conviction and sentence, the disqualification comes into being immediately. But what happens if a sentence gets stayed? Do you think that all such people who have a conviction, who are facing an appeal, but who have a stay on sentence should also be automatically disqualified? Maybe there is some play in the joints there.
Interesting. Well, that's a very interesting discussion. We're running out of time, Mr. Hegde. We're coming to final comments. A final word from you. April 13th is when the application will be taken up for stay of conviction. Should it not happen, what then is the remedy available to Rahul Gandhi? And how do you see all of this playing out when you see it in the lens of the upcoming Lok Sabha elections?
I am not a political analyst, so I won't go there. If there is no stay granted, then the remedy is obvious. Go to the High Court. It's, of course, an open question of whether the High Court or the Supreme Court will say that we will grant a stay, or they will say that, we do not interfere at the interim stage. Finish the appeal first, and then we will hear you.
Mr. Sood, final comments from you. Again, looking at it from the lens of what's expected 12 months from now, the Lok Sabha elections. Do you see this perhaps as being a factor of these cases being filed against the opposition parties? Do you see that as a uniting factor, or do you see that as perhaps a factor that may demoralize the opposition forces?
I'm not a political man, and I'm not a psephologist, who can predict, what happens in the political landscape. But definitely, what happens on 13th of April, the future, if suppose the conviction and the sentence are not stayed, obviously Mr. Gandhi will file a revision petition or a 482 petition before the High Court, because it won't be appealable. So as you go higher, the challenge becomes narrower purely on questions of law, and revisionary jurisdiction and extraordinary powers of the High Court. These jurisdictions are very narrow. So let's see how this pans out.
Sure.
But definitely, if he is not granted relief, it will be subjected to challenge in the higher court.
Sure. So indeed, that's the key date to watch for, April 13th. That's when the Sessions Court in Surat will be taking up Rahul Gandhi's application seeking a stay of the conviction. The big D-Day, April 13th. I'd like to thank both of our panelists, Mr. Hegde as well as Mr. Sood, for taking out their time for addressing the subject and speaking to us on the issue. But with that, it's time now to head into a very small break. Up next, we understand that the first heat wave and now unseasonal rains, farmers are staring